Welcome to this video presentation on the mortgage servicing rules. Many FDIC-supervised institutions that service mortgage loans are community banks that qualify as small servicers under the rules. So we have developed this video with a focus on small servicers. In this video, we look at the servicing requirements applicable to small servicers, which are also applicable to large servicers, except as otherwise noted. This video does not discuss servicing requirements for large servicers, from which small servicers have an exemption. We will talk about requirements found in Regulation Z, and then we will discuss requirements from Regulation X, focusing on the implications of these requirements for small servicers. Throughout the video, the term day refers to calendar days, unless otherwise specified. We will discuss Regulation Z requirements that apply to all servicers, including prompt payment crediting, payoff statements, and interest rate adjustment notices. We will discuss Regulation X requirements that apply to all servicers, including payments during mortgage servicing transfers, forced place insurance, error resolution and information requests, and applicable loss mitigation rules. Before we go through these requirements in more detail, note that Regulation Z uses the term consumer and Regulation X uses the term borrower. We will use these terms interchangeably throughout this video.
Let's start with the requirements in Regulation Z applicable to all servicers that ensure proper application of payments and consistency in handling partial payments. The first step is to become familiar with the payment definitions. A periodic payment means an amount sufficient to cover principal, interest, and escrow, if applicable, for a given billing cycle. A payment qualifies as a periodic payment even if it does not include amounts required to cover late fees, other fees, or non-escrow payments you have advanced on a borrower's behalf. A partial payment is any payment less than a periodic payment. As a servicer, generally you are required to promptly credit a periodic payment as of the date of receipt, unless a delay in crediting does not result in any charge to or negative credit reporting about the borrower. You may specify in writing reasonable requirements for making payments. It should not be difficult for most consumers to make conforming payments. Examples of reasonable requirements include setting a cutoff hour for payment to be received or setting different hours for payment by mail and payments made in person. Specifying that only checks or money orders should be sent by mail, or specifying one particular address for receiving payments, such as a post office box. Non-conforming payments are payments that are submitted in a manner inconsistent with reasonable payment requirements that you have set in advance. The accounting method for creating periodic payments is based on the terms of the parties' agreement, subject to applicable law. When accepting non-conforming payments, they must be credited as of 5 days after receipt. If you receive a partial payment from a borrower, you may take any of the following actions to the extent the action is not prohibited by law or contract. Credit the partial payment upon receipt, return the partial payment to the borrower, or hold the payment in a suspense or unapplied funds account. You may hold a partial payment in a suspense or unapplied funds account, but you are not required to do so. However, if you do, once the suspense account has accumulated sufficient funds to cover a periodic payment, you must treat those funds as a full periodic payment received and credit the payment to the borrower's loan account. If you choose to place partial payments in a suspense or unapplied funds account, periodic statements must disclose the total funds held in that funds account. If a borrower or person acting on their behalf makes a written request for the payoff balance of a mortgage loan, you must provide an accurate statement within reasonable time, but no more than 7 business days after receipt of the written request. The statement must contain the total amount required to pay the borrower's obligation in full. If you cannot provide the statement within 7 business days because the loan is in bankruptcy or foreclosure, the loan is a reverse mortgage or shared appreciation mortgage, or due to natural disasters or other similar circumstances, you must provide the payoff statement within a reasonable time. Regulation Z requires all servicers to provide notice for the initial reset of the interest rate on a closed-end adjustable rate mortgage loan, or ARM, secured by a principal dwelling, and each time an interest rate adjustment results in a payment change. These notices are intended to give borrowers sufficient time before their home mortgage interest rate resets to explore available options such as refinancing or adjusting their budget. Regulation Z specifies the content and format of the notices and provides model forms you can use. Among other things, the notices have to include a table containing the current and new interest rates, the current and new payment amounts, and the new due date. There are 2 types of these notices. One is the initial interest rate adjustment notice, referred to as the initial notice. The initial notice generally must be provided at least 210 days, but no more than 240 days before the first payment at the new adjustment rate is due. The other notice is the advance notice of any subsequent interest rate adjustment that results in a corresponding change in payment amount, referred to as the advance notice. The advance notice generally must be provided between 60 and 120 days before the first payment at the new rate is due. As noted on the previous slide, the initial notice must be provided the first time the interest rate on the ARM adjusts. The initial notice is not required if the loan term is 1 year or less. If the first payment at the adjusted rate is due within the first 210 days after consummation, you must provide the disclosure in the initial notice at consummation. The advance notice is required each time the interest rate adjustment results in a payment change unless the loan term is 1 year or less. This includes a conversion of an ARM to a fixed-rate mortgage loan if the interest rate adjustment results in a payment change. There are special timing requirements to provide the advance notice for the following loans: ARMs that are scheduled to adjust every 60 days or more frequently, ARMs originated before January 10, 2015 with look-back periods less than 45 days, and ARMs adjusting within 60 days of consummation. We won't discuss those requirements here, but you can check Regulation Z for more information.
We will now move on to Regulation X, servicing requirements applicable to all servicers. Keep in mind the different scope of the rules in Regulation X and Regulation Z. You can check CFPB resources for specific information. Let's start our discussion of Regulation X requirements with how to handle payments received after a transfer of servicing. All servicers must provide the applicable notices of transfer of loan servicing. If you are transferring a loan to another servicer, beginning on the effective date of transfer, Regulation X requires you to promptly transfer any payment received to the transferee servicer or return any payment received to the consumer, along with instructions on how to make payments to the new servicer's payment mailing address. Also, any on-time payments you receive on or after the effective date of the transfer may not be treated as late for any purpose for a period of 60 days. Next, let's discuss forced place hazard insurance. When a hazard insurance policy purchased by the borrower for their property has lapsed or is insufficient, you may need to obtain forced-placed insurance. Generally, this insurance may provide limited coverage at a higher price than hazard insurance the borrower would have obtained. All servicers must comply with the notice and other requirements before charging a borrower for forced-placed insurance. Requirements apply prior to the initial purchase of forced-placed insurance and any subsequent renewal or replacement of that insurance purchased by the servicer. Small servicers do have a limited exception related to escrow accounts, as we will discuss later. Please note that these requirements apply to hazard insurance required by the loan documents, and not to federally required flood insurance. This video does not address requirements under the Flood Disaster Protection Act. Before you can assess a charge on the borrower for force-placed insurance, you must have a reasonable basis to believe that the borrower has failed to maintain hazard insurance required by the mortgage loan contract. You also must have sent the appropriate notices, as we will discuss shortly. You may have a reasonable basis because you have received information from the borrower, the borrower's insurance provider, or the borrower's insurance agent, indicating that a borrower's hazard insurance has lapsed or is insufficient. If the borrower provides evidence of hazard insurance coverage, the servicer is required to cancel the force-placed policy within 15 days of receipt and refund any force-placed insurance premiums charged during the period of overlapping insurance coverage. Upon determining the borrower purchase policy is expiring, has expired, or has insufficient coverage, servicers must send 2 notices to the borrower. The first notice is sent at least 45 days before assessing a fee or charge to a borrower related to force-placed insurance. The second, reminder notice, is sent no earlier than 30 days after the first notice, and at least 15 days before charging the borrower for force-placed insurance. You may need to renew or replace the existing force-placed insurance if the borrower does not purchase their own hazard insurance. In this case, you must send the borrower a renewal notice at least 45 days before you assess a replacement or renewal charge. You only have to provide the written renewal notice once per year. You can check the rules and CFPB resources for specific information about these notices and their timing requirements. Consider the following example. After receiving a notice from the borrower's insurance provider stating that the insurance has lapsed, you, as the servicer, purchase force-placed insurance for the property. In order to establish a reasonable basis to believe that a borrower is not in compliance with the requirement to maintain insurance on their home, you send the borrower the first notice. After 30 days, you have received no evidence of sufficient insurance, and so you send the second notice. You have reviewed the regulation, and you send both notices in compliance with the timing and content requirements set forth in Regulation X. 15 days after you send the second notice, you charge the borrower for force-placed insurance. 3 days after charging the borrower for force-placed insurance, you receive evidence of hazard insurance coverage from the borrower. What do? Under Regulation X, within 15 days of receiving evidence of coverage, you must cancel any force-placed insurance you purchased for the borrower, refund to the borrower all force-placed insurance premium charges and related fees for any period of overlapping insurance coverage, and remove from the borrower's account all force-placed insurance charges and related fees for the overlapping period. If a borrower has an escrow account for payment of hazard insurance, the servicer can maintain the borrower's existing coverage by advancing funds through the escrow account to pay the existing policy premium. The escrow account rules in Regulation X do not allow servicers to purchase force-placed insurance for overdue borrowers with escrow accounts unless a servicer is unable to disburse funds from the borrower's escrow account to pay the premium charges. A servicer is considered unable to disburse escrowed funds only if the borrower's hazard insurance was canceled or not renewed for reasons other than non-payment of premiums, or if the borrower's property is vacant. Having insufficient funds in the escrow account to pay an insurance premium does not constitute an inability to disburse funds. Servicers can maintain existing coverage by advancing funds through the escrow account and may seek repayment from the borrower for such advanced funds, unless otherwise prohibited by law. However, the rules allow small servicers, under certain conditions, to purchase forced-place insurance for escrowed borrowers whose payments are more than 30 days overdue, and to charge the cost of the insurance to the borrower. This type of exception is available even if the small servicer is not considered unable to disburse funds from the borrower's escrow account. In this situation, the purchase of forced-placed insurance is allowed only if the borrower's cost of forced-placed insurance is less than the amount the small servicer would need to disburse from escrow to ensure timely payment of the borrower's premium.
Let's talk about the Regulation X requirements for resolving errors raised by a borrower's notice of error and for responding to requests for information from borrowers. The error notice and information request rules have some similar and some different requirements. Regulation X prohibits servicers from charging a fee or requiring a borrower to make a payment as a condition of responding to a notice of error, often referred to as error notice, or information request, other than for providing beneficiary notices under state law. Although you may respond to an error notice or information request submitted orally, the rules only apply to requests that are in writing and that contain the borrower's name and account identifying information. Additionally, the error notice must include a description of the error, and the information request must include a statement of the information requested. A notice on a payment form or coupon or a request for payoff balance is not considered an error notice or information request. Error notices cover 10 categories of servicing and also a catch-all category. Some examples of these categories include failure to comply with payment and escrow requirements, failure to provide accurate information regarding loss mitigation options and foreclosure, and failure to provide accurate and timely servicing transfer information to a transferee servicer. The error resolution procedures do not apply to non-covered errors relating to the origination of underwriting of a mortgage loan, a subsequent sale or securitization of a mortgage loan, or a determination to sell, assign, or transfer the servicing of a mortgage loan. While you are not required to respond in these cases, you may want to do so for customer service or other reasons. The rules include certain timing requirements if you receive an error notice. The rules require servicers to acknowledge an error notice or provide early notification of correction in a written response within 5 days of receipt, excluding holidays and weekends. For most types of errors, servicers generally have 30 days, excluding holidays and weekends, to correct the error and provide written notification of the correction to the borrower. You may extend the time period for responding by an additional 15 days, excluding holidays and weekends. However, you may only do so after first providing the borrower a written notice of the reasons for the extension. If an investigation revealed no error, you must provide written notification of no error to the borrower, state the reasons for this determination, and include contact information for the borrower to request supporting documentation or further assistance. Shorter timeframes may apply where the error notice relates to a pending foreclosure or payoff statement containing an inaccurate payoff balance. Additionally, if you receive an error notice, you may not, for a period of 60 days, furnish adverse information to any consumer reporting agency regarding any payment that is the subject of the error notice. The timing requirements for responding to information requests are similar to error notices. Within 5 days, excluding holidays and weekends, of receiving an information request, you must send a written acknowledgement of receipt or provide the information requested and contact information in writing. For most information requests, the rules require you to provide the information or conduct a reasonable search for the requested information within 30 days, excluding holidays and weekends. You may extend the time period for responding by an additional 15 days, excluding holidays and weekends. However, you may only do so after first providing the borrower a written notice of the reasons for the extension. If the information is unavailable, provide a written notification explaining why the information is not available, and include contact information for further assistance. A shorter time frame, 10 days, excluding holidays and weekends, applies when the consumer requests the identity, address, or other contact information for the owner or assignee of a mortgage loan. This time period may not be extended. There are certain specified circumstances in which you do not need to comply with the usual response requirements for error notices and requests for information. Specifically, if you reasonably determine that one of the following reasons apply: the error notice or information request is duplicative or untimely, the error notice is overbroad, or the information request is overbroad or unduly burdensome. Response requirements also do not apply if the information requested is irrelevant, confidential, proprietary, or privileged. Instead of the usual response requirements, you are required to notify the borrower in writing no later than 5 days after determining that one of these reasons apply, excluding holidays and weekends. The notice must include the reasons for your determination.
Loss mitigation is the final topic we will discuss in this video. While most of the loss mitigation procedures apply only to large servicers, small servicers are subject to the prohibition on foreclosure referral. This prohibition is related to dual tracking, which refers to taking action to foreclose while a borrower seeks loan modification or other options. Specifically, small servicers must comply with the prohibition on referring a mortgage loan to a foreclosure process unless one of the following occurs: a delinquency of more than 120 days, which effectively pauses the initiation of foreclosure for at least 120 days from the start of the delinquency, a violation of a due on sale clause leading to a foreclosure, or the servicer joins the foreclosure action of another lien holder. In addition, if a borrower is performing under a loss mitigation agreement, small servicers are prohibited from initiating the foreclosure process, moving for a foreclosure judgment or order of sale, or conducting a foreclosure sale. These requirements apply to mortgage loans secured by a borrower's principal residence. Depending on the facts and circumstances and applicable state law, a vacant property may still be a borrower's principal residence. For instance, this scenario could occur when a service member relocates due to a permanent change of station orders, but intends to return to the property. For the purposes of determining the 120-day period of delinquency before making a foreclosure referral, the mortgage loan is delinquent beginning on the date a periodic payment sufficient to cover the principal, interest, and, if applicable, escrow payments becomes due and unpaid. The starting date does not change even if you provide a grace period for a borrower to pay without a late fee. That means, if a payment is due on the first of each month, but you provide a courtesy period in which you will not impose a late fee until the 15th of each month, you would still count the delinquency as starting on the first of the month. The loan then remains in delinquency until no periodic payment is due and unpaid. In a fact sheet on delinquency, the CFPB provides examples of delinquency for purposes of periodic statement content and loss mitigation requirements, known as early intervention and continuity of contact, which apply to large servicers. The fact sheet on delinquency also describes a rolling delinquency, which occurs when a payment is applied to the oldest outstanding periodic payment, advancing the date the delinquency begins. In this scenario, any payment that satisfies a scheduled periodic payment advances the date that the delinquency begins, regardless of when the payment is received. Servicers are not required to apply payments in this manner, but the rules and the CFPB resources address how to calculate the length of a delinquency if you do. Let's look at an example. A mortgage loan requires periodic payments of principal, interest, and escrow by the first of each month, but the borrower does not make their July payment. On July 31st, the borrower is 30 days delinquent. Then, on August 8th, the borrower makes a periodic payment. If your entity's practice is to apply payments to the oldest outstanding periodic payment, in this scenario, the payment due on July 1st, then on August 8th, the borrower is 7 days delinquent for the purposes of specified provisions in the rules. This concludes our video on mortgage servicing requirements applicable to small and large servicers. This video does not discuss additional servicing requirements for large servicers that provide an exemption for small servicers. This video covered a lot of ground. Let's quickly go over the topics that we discussed. Regarding payment processing, servicers are required to promptly credit periodic payments so that the borrower does not accrue late fees due to processing delays. We also talked about how to handle a partial payment or a payment received after you have transferred the mortgage loan to another servicer. When it comes to adjustable rate mortgages, communication is key, and the rules include specific timing requirements for notifying borrowers when the interest rate changes. During this video, we also talked about what the rules require if you determine that the borrower does not have sufficient hazard insurance for their property, including the notices you must send before you can charge a borrower for forced place insurance, and the timing and content of those notices. Servicers cannot purchase forced place insurance exclusively because a borrower's escrow funds are too low to pay the hazard insurance premium. The servicer can maintain existing coverage by advancing funds through the escrow account. Small servicers, however, are permitted to purchase less expensive forced place insurance for borrowers whose escrow payments are more than 30 days overdue. We also walked through how to respond to error notices and information requests, including timing requirements for investigations and responses. Finally, we discussed loss mitigation requirements for which there is no small servicer exemption. While small servicers are exempt from many of the loss mitigation requirements set forth in Regulation X, they must comply with the prohibition on foreclosure referral if the mortgage loan is less than 120 days delinquent, and the prohibition from taking steps in the foreclosure process if a borrower is performing under a loss mitigation agreement. The rules define the term delinquency and provide information on how to determine the length of a delinquency for the application of certain requirements. Thank you for watching this video on the mortgage servicing rules. We hope you found it both useful and informative.